Hey there, welcome to the College Investor Audio Show. A little bit of a change up on topics today, which I think is welcome since we've had so much student loan discussion for months and months on end, and probably more to come anyway. But 5 beneficiary designation mistakes that can wreck your estate plan. That is the topic today. Very interesting topic and something that a lot of us just kind of push off, but shouldn't. We should not be pushing this off. Got to get your estate plan in order. All right, before we get to it though, I just want to remind you, anytime you hear a topic, there's an article with it where you can dive deeper on every topic we talk about at thecollegeinvestor.com. Go there and you have a ton of information at your fingertips. Okay, so you spent thousands on an estate plan. You signed the will. You funded the trust. None of it matters. Maybe because a beneficiary form you filled out 15 years ago when you started a new job could override everything. Beneficiary designations on retirement accounts, life insurance policies, payable on death bank accounts are legally binding contracts. They operate entirely outside of your will and trust. People don't realize this. So when these forms are outdated or incomplete or even misaligned with the rest of your plan, the result can be assets going to an ex-spouse, a child being accidentally disinherited, yeah, it's happened, or even a 6-figure tax bill no one saw coming. According to Caring.com's 2025 estate planning survey, only 24% of American adults have a will, which is down from 33% in 2022. That's alarming. But even among the minority who do plan, beneficiary designation errors remain one of the most common and costly oversights. So here are 5 mistakes you got to avoid. Number 1, failing to update your beneficiaries. This is the most frequent one, often the most damaging too. You get married, you divorced, you have a kid, you lose a spouse. The beneficiary forms on your 401k, IRA, and life insurance policies stay exactly the same. It doesn't care if you've divorced. Just sorry, you got to fix them. And the legal consequences of not fixing this are real. In the 2001 Supreme Court case, Egelhoff versus Egelhoff, the court ruled that a former spouse was entitled to a deceased person's life insurance proceeds because the beneficiary form was never updated after the divorce. Ouch. Even though state law would have revoked the designation, federal law, ERISA, governed the employer plan and the form won. The fix is pretty straightforward, too. It takes a couple minutes. Review every beneficiary designation after any marriage, divorce, birth, death, or major financial change. Keep a master list of all accounts that carry beneficiary designations and update it annually. Set an alarm on your phone. Annually update your beneficiary form. All right, mistake number 2. Assuming your will overrides beneficiary designations. This misconception trips up families all the time. A will only governs assets that pass through your estate, meaning assets that don't already have a named beneficiary or surviving joint owner. Retirement accounts, life insurance, annuities, payable on death bank accounts, all of them bypass the will entirely. So, if your will says everything goes to my 3 children equally, but your $500,000 IRA still names your ex-spouse, your ex gets the $500,000, your children get nothing from that account. And there's really little recourse for this, little legal recourse anyway. Americans hold more than $9 trillion in employer-sponsored retirement plans and IRAs. For a lot of families, these accounts represent the largest single asset in the estate. Treating the beneficiary form as an afterthought is a significant financial risk. Number 3, skipping contingent beneficiaries. A lot of people name a primary beneficiary and they leave the contingent or the backup line blank. This creates a serious problem if your primary beneficiary dies before you do, or at the same time. in like a common accident, car accident type of thing, the account defaults to your estate. That means it goes through probate, which is the exact outcome most estate plans are designed to avoid. Probate just adds time, legal fees, and public disclosure. For retirement accounts, it can also accelerate tax consequences. Boo. When an IRA passes through an estate rather than directly to a named beneficiary, the distribution rules become less favorable, potentially forcing faster withdrawals and a bigger tax hit. Always, always, always name at least one contingent beneficiary on every account. If your situation is complex, like blended families, minor children, or even a special needs dependent, consider naming a trust as the contingent beneficiary, but only with guidance from an estate planning attorney. Number 4, naming your estate as the beneficiary. Some account holders deliberately name my estate as the beneficiary, thinking it just kind of simplifies everything, right? But it actually does the opposite. Naming your estate as the beneficiary of a retirement account or life insurance policy forces the asset through probate. It strips away several tax-advantaged options for your heirs. So when a retirement account passes directly to a named individual, the beneficiary can just stretch distributions over a period of like 10 years or so, up to 10 years. When it passes to the estate, the account may need to be distributed within 5 years, maybe even faster than that, depending on whether the original owner had started required minimum distributions. That compressed timeline can push heirs into higher tax brackets. Yikes. Life insurance proceeds are similar to this too. Paid to a named beneficiary, they're generally income tax-free. If they're paid to the estate, they become part of the probate estate, subject to estate taxes and creditor claims. Not good. The fifth thing and last thing we're going to talk about, relying on joint accounts instead of proper designations. Some families try to sidestep estate planning altogether by adding a child or family member as a joint owner on bank accounts, investment accounts, or even real estate for that matter. The logic seems simple. When one owner dies, the other just inherits it. But joint ownership comes with serious risks that most families just don't even consider. A joint account holder has full legal access to the funds during both owners' lifetimes. That means the account is exposed to the other owner's creditors, lawsuits, divorce proceedings, financial mismanagement, etc. If your adult child racks up debt, or gets sued for that matter, those joint-held funds could be seized. Joint accounts can also create unintended tax consequences and financial aid complications. As the College Investor has covered in detail, parent-child joint accounts carry hidden financial risks that range from Medicaid eligibility problems to FAFSA reporting issues. Here's a better approach. Use payable on death, or POD, or transfer on death, TOD, designations on bank and investment accounts. These keep the account in your name alone during your lifetime, but they do transfer automatically to your named beneficiary at your death, without probate and without the risks of joint ownership. Okay, so here's what this means for your family's finances. Beneficiary designation mistakes don't just create legal headaches. They directly affect your whole family's financial security. An outdated form can redirect hundreds of thousands of dollars away from the people you intended to protect. A missing contingent beneficiary can trigger probate costs that eat into your heirs' inheritance. A joint account set up for convenience can expose your savings to someone else's creditors. The financial stakes are particularly high for families with retirement accounts as their primary asset. With the average 401k balance for Americans aged 55 to 64 exceeding $200,000, a single beneficiary error can redirect a meaningful portion of a family's wealth. Not good. That is our show for today. I hope you took that to heart and you at least, are going to think about, maybe I should check on this stuff. It'd be a good idea too. If you think this can help somebody else, please feel free to share this with somebody. We'd greatly appreciate that. And thank you so much for stopping by the way. Anytime you have any questions, comments, you would like just to get to know us better. We'd love to get to know you too. Wherever you are in your family planning or financial journey at all, we'd love to help you any way we can. At The College Investor, search for those words and you'll find us on social media pretty much anywhere you are. Thanks so much again for stopping by, and we will talk to you again real soon.